Straight ahead on Law and Crime Daily. Former New York Governor Andrew Cuomo charged with sexual assault. Angenette Levy is live with the latest from Friday's press conference. And a former gubernatorial candidate takes the stand in his own trial for murder.
It was a polite way of flipping them the bird.
Plus,
domestic violence is not always physical.
What we learned about domestic violence from the Gabby Petito case. And later, the courtroom gets heated in the second murder trial for Markeith Loyd.
Mr. Loyd, we are not listening to you right now.
Law and Crime Daily, covering court cases from coast to coast. Welcome to Law and Crime Daily, everybody. I'm Jesse Weber in for Brian Buckmeyer. With me, as always, co-host Terry Austin. Former New York Governor Andrew Cuomo now faces a misdemeanor criminal charge accused of groping a former staffer. But as Angenette Levy tells us, that charge came as a surprise to the DA.
That's right, Jesse. An Albany County Sheriff's detective filed the criminal complaint on Thursday, charging Andrew Cuomo with forcible touching. But the DA's office issued a statement saying they didn't even know this was coming. They were taken aback by it. David Soros' office tweeted, like the rest of the public, "We were surprised to learn today that a criminal complaint was filed in Albany City Court by the Albany County Sheriff's Office against Andrew Cuomo. The Office of Court Administration has since made that filing public. Our office will not be commenting further on this case." Sheriff Craig Apple, for his part, says his agency followed procedure by dropping off the documents at the courts, and the summons and complaint became public more quickly than expected. Now, these allegations of forcible touching involve Brittany Camiso, a former staffer for Cuomo. The complaint states Cuomo placed his hand forcibly under Camiso's blouse and touched her left breast for his own sexual gratification. You may recall Cuomo resigned after a report released by New York Attorney General Letitia James documented a number of complaints from women against Cuomo. James has since announced just recently that she is going to run for governor. But Cuomo's attorney, Rita Glavin, issued a statement saying Governor Cuomo did not assault anyone and called Sheriff Apple's motives patently improper since the sheriff did not communicate with the DA about this. She said, "This is not professional law enforcement. This is politics." Sheriff Apple, meanwhile, says the case is solid. Jesse?
All right, let's break it down. Joining me again, co-host Terry Austin, and also former prosecutor Melba Pearson. Melba, I want to start with you. Why would the sheriff's office file the complaint without notifying the prosecuting office? I mean, does that mean that they don't agree on how strong this case is?
Not necessarily. So there could be a number of reasons for this, Jesse. First off, the sheriff may be trying to keep politics out of this, right? And so he may be like, listen, I'm going to file these charges. I'm not going to worry about having a situation where I tell the prosecutor's office and then they turn around and tell me, oh, don't file because, this is problematic for us from a political perspective. So that is one option. But I will say it is unusual because usually the sheriff's office and the district attorney's office of every city have somewhat of a professional collegial relationship. And in a high-profile case of this nature and of this magnitude, you would have thought that a heads up would have been given.
Terry, Ms. Camiso is claiming that Cuomo forcibly touched her. Legally, what exactly does that mean, and what could Cuomo face in terms of jail time, sex offender registration? Walk me through it.
Well, a forcible touching is a misdemeanor, Jesse, and the penalty would be up to 1 year in jail. But the prosecution is going to have to show that the touching was not accidental, meaning that it was intentional, and also that it was forceful. And frankly, if he's convicted, he would not have to register as a sex offender because in this case, the victim was not under 18, and it's Cuomo's first offense if, in fact, he is convicted. So we'll have to see what happens.
Angenette, what is next for Cuomo as this charge goes through? I mean, when are we going to see him? Is he going to be in handcuffs? What's going to happen?
Well, this isn't a case where you do see somebody kind of handcuffed and arrested immediately. They issued a summons, meaning it's like a piece of paper. They send it to him and his lawyer, and it says you have to appear in this court on this date at this time. So he's going to appear in court on November 17th. That's when he's scheduled to appear. At that time, we are told he will be fingerprinted, a mugshot will be taken. all of the things that typically happen when someone is arrested.
Yeah, and what's shocking to me is when I read that complaint, how specific it was in terms of the time frame of this alleged incident. So when I think about that, I'm thinking, okay, this must be backed up by other evidence, whether surveillance footage from the executive mansion actually laying out how long she was there, or even text messages to corroborate this. So it's going to be very interesting to see what this case is and what they ultimately have presented, and maybe the DA and the sheriff's office will get on the same page. All right, we'll continue to follow it. On to news out of Idaho right now, where a court filing alleges unethical and possibly illegal activity involving half of the so-called Doomsday Duo. The attorney for Lori Vallow Daybell says that a state-issued clinician persuaded her to contact the Church of Jesus Christ of the Latter-day Saints, telling her it was part of her homework for treatment. Court documents allege that Daybell contacted an LDS attorney and gave him important information about her case. Daybell's attorney now says the LDS attorney contacted a state prosecutor with that information, acting unethically and making a Brady violation. Now, under a Brady disclosure, the prosecution is required to disclose exculpatory evidence about a defendant. That means that could negate the defendant's guilt. Daybell's attorney now wants to depose the LDS attorney and subpoena records from the Idaho Department of Health and Welfare to determine whether her rights were violated. At the time of this incident, Daybell was staying at the Idaho State Hospital. She's now being held by the Idaho Department of Health and Welfare after she was deemed incompetent to stand trial. Vallow Daybell and her husband, Chad Daybell, are accused of killing her two children, Tylee Ryan and J.J. Vallow. The bodies of both children were found on Chad Daybell's property, in June 2020. Still ahead on Law&Crime Daily, October is Domestic Violence Awareness Month, and we hear from experts who are hoping to curb the number of cases. But first, a cold case murder suspect testifies in his own defense. We take you to Colorado, where a former gubernatorial candidate is accused of kidnapping and murder.
It was the video that shocked the nation. An unarmed black jogger, 25-year-old Ahmaud Arbery, gunned down in broad daylight. The three-man charge will now stand trial. For live gavel-to-gavel coverage of the trial, subscribe to Law&Crime on YouTubeTV today.
And welcome back to Law&Crime Daily, everybody. A Colorado man takes the stand in his own defense in an abduction and murder cold case nearly 4 decades old. It's been 37 years since 12-year-old Jonelle Matthews went missing in her Greeley, Colorado neighborhood. Matthews was returning home in 1984 after a school Christmas concert. Matthews was declared legally dead in 1994, and remains were finally discovered in July 2019. It was then that her cause of death was revealed as a gunshot wound to the head. 70-year-old Stephen Pankey, who previously ran for governor of Idaho, was a person of interest in the case at the time of Matthews' disappearance. He lived 3 miles from the Matthews family home and was a pastor at her church. His ex-wife told investigators that in the days following the disappearance, Pankey showed an unusual interest in the case, obsessively reading newspaper articles and listening to the radio reports on the case. Pankey was indicted by a grand jury over a year ago for the disappearance and death of the 12-year-old. Pankey's trial began earlier this month. On Thursday, the defendant took the stand in his own defense, claiming that he didn't know the victim before learning about her disappearance.
Let's clarify, Mr. Pankey. On the night of December 20th, 1984, did you drive to the Matthews home?
No, I didn't know who the Matthews were.
Though Pankey maintains that he didn't know of the victim until after she went missing, he admitted to misleading investigators out of bitterness and revenge for his former employer, saying he had hatred towards law enforcement.
So the truth is that I made a lot of stuff up out of bitterness for things that happened to me at Sunnyview and for things that happened to me at 7-Up. And my revenge on them was to And because I hated the police, it was all in one to say, I've got information that you want and you can't have it. It was a polite way of flipping them the bird. It was pure hatred on my part.
Wow. Okay, so Terry, this is an odd case as well as an old case, and there's no DNA evidence linking Pankey to the crime. Do you think that his strange behavior, the obsession about the case, that is going to be enough to convict him here?
Jesse, I think this is going to be a very difficult case for the prosecution. First of all, you have an upstanding citizen who ran for governor. He was a pastor. And what was his motive here? The fact that there's no DNA does not help the prosecution. I will say that his behavior was quite odd. The fact that he is obsessing about the case, and even his wife testified against him. They went up to Big Bear Lake and they came back, and he heard about it on the radio, and he wanted to stop at a Safeway and get the newspaper. And he also denied having digging in his front yard the day after the woman disappeared. So all of his behavior is quite strange, and I think that connecting it all together is going to be a little bit hard for the prosecution.
Melba, I can't think of who better to ask this than you. If you were to cross-examine him, what areas would you hit?
Well, first of all, the reality is his story doesn't make any sense. You know, why are you going to bring in this young girl, use this case where a young girl was went missing and was murdered, and she was a member of your church? That's the case you're going to use to politely flip off the police? It doesn't make sense. So I would be heavily cross-examining him on that aspect, heavily cross-examining him on the fact that he was behaving in such a strange manner, that he was obsessed with the case, and that it doesn't make sense that this is a member of his church and he has no clue who she was or her family was. Again, it flies in the face of common sense.
It's like the Robert Durst syndrome. I'll admit to lying on the stand, so believe me now. I don't know. It's a strange one. Over now to a judge ruling in favor of Kobe Bryant's widow, ordering LA County officials to make court depositions after leaking graphic images of the NBA star's deadly helicopter crash. Vanessa Bryant sued the county for negligence and invasion of privacy after she claims first responders took photos of the 2020 crash and later posted them. Bryant, his 13-year-old daughter Gianna, and 6 other people died tragically in that crash. The Bryant family has made claims for violation of civil and privacy rights as well as emotional distress. The judge's ruling comes days after Los Angeles County filed a motion that would require Bryant to undergo psychiatric evaluation. The motion also includes psychiatric evaluation requests for all 3 of her children, all under the age of 14. And coming up on Law and Crime Daily, an argument in the courtroom where the judge tells the defendant to be quiet. This is all in Markeith Loyd's second murder trial. Plus, the death of Gabby Petito sheds light on the dark side of domestic violence, what experts say you should look for in warning signs. All that and more next. And welcome back. Gabby Petito's death furthered the conversation about domestic violence and how to help victims. The story consumed the news for much of October, which is Domestic Violence Awareness Month. Angenette Levy spoke with an expert who helps these victims.
Gabby Petito's father, Joe, says he is not focused on what may or may not be in a notebook owned by Brian Laundrie that was found after he died. Instead, he says he is focusing on helping victims of domestic violence.
He like grabs my face, like this. He didn't like hit me in the face, like he didn't like punch me in the face or anything.
You've seen the body camera video showing Gabby Petito during a traffic stop after a 911 caller reported seeing Brian Laundrie hitting her. Petito's death has renewed the conversation about domestic violence.
Domestic violence is not always physical.
Maureen Curtis works for Safe Horizon, an organization that helps domestic violence victims. She says domestic violence is all about power and control.
A term that's commonly used is coercive control, where a person doesn't have to be physical, but it doesn't mean that they're not threatening.
Curtis says questions have been raised about how the, quote, van life experience could impact a domestic violence situation, since one tactic used by abusers is isolation.
And if you're traveling around the country, if you're living in a small confined space, it's more likely that there could be escalated tension that could lead to violence or escalated violence.
Survivors can learn lessons from Petito's case, but so can those who know someone who is the victim of domestic violence.
You know, stepping in a safe way to help that person, even if it's just to talk to that person or to listen to that person, to never underestimate how powerful that can be.
There is a national domestic violence hotline that's open 24/7. The number is 1-800-799-SAFE. For Law and Crime Daily, I'm Angenette Levy.
So important. In South Carolina now, a monumental settlement is reached as the Department of Justice grants $88 million to the families of the Charlton Church massacre. The settlement funds range between $6 million and $7.5 million per claim and $5 million for survivors. All this comes after a lawsuit brought to the DOJ over the shooter's purchase of the weapon. Dylan Roof was convicted of federal murder in 2016 after he opened fire at a historically black church in Charleston. 9 people were killed and 1 other was injured. In 2019, the Federal Court of Appeals ruled that the families could sue the government for negligence after multiple lapses in background checks that allowed Roof to purchase the semi-automatic pistol that he used. In 2017, Roof was sentenced to death for his crimes. Well, this week on the Law and Crime Network's podcast, Cocktails and Cocktails, Sergeant Sean Sticks Larkin sits down with Lieutenant Jeffrey Postal, the once rookie officer who caught the man who set off a bomb at the 1996 Olympics in Atlanta.
And as I came around the corner of the building, I saw an individual kind of crouched down in the roadway as if they were kind of sneaking, or if you will, going towards the rear of the business. 2:30, 3 o'clock, 3:30 in the morning, there's not a lot going on in those businesses. And I always said there's only 2 types of people out at that time, especially behind the business, cops and crooks. Yep. And I knew I was the only cop on duty at that time, so I knew that he wasn't a friend.
What a hero. You can listen to this week's Cocktails and Cocktails episode now on Apple Podcasts or wherever podcasts can be found. When we come back, the courtroom heats up in the second murder trial for Markeith Loyd. We take you inside the Florida courtroom to hear the argument between the defense attorney and the judge about a charge that is nearly 20 years old. Welcome back. In Florida, the defense begins its case in the second murder trial for Markeith Loyd. The state rested on Thursday after only a few days of testimony. Loyd is on trial for the murder of Lieutenant Deborah Clayton, who was killed while attempting to arrest the defendant outside of a Walmart. Loyd was previously charged and convicted for the murder of his pregnant ex-girlfriend, Sade Dixon. In that case, he avoided the death penalty and was sentenced to life in prison. Loyd has a long history of convictions stretching back to 1994 with over 20 arrests. However, if convicted in this case, Loyd will face the death penalty again. Loyd was also found guilty back in 2002 for attacking a corrections officer while at that time in jail for another charge. The state wanted to bring this case into evidence to establish a history of violence with Loyd, but the defense began their case with testimony on Friday, and before calling any witnesses, the defense argued against including this evidence.
So,
but there's no evidence of a violence before the court.
Hold on. Let me finish.
Thank you.
Where it says a mutiny occurs. That's what it says, occurs when inmates acting together resist a prison warden or his subordinate officers in the free and lawful exercise of their legal authority. So would not slamming an officer to the ground constitute a mutiny?
Absolutely not. Absolutely not.
Because what? Do you have some law that says that? Or that's just your opinion, Mr. Loyd?
It's
talking. Listen. Mr. Loyd, we are not listening to you right now. Go ahead.
But maybe they will listen to him because, Melba, we're hearing rumblings that the defendant himself may testify like he did in his first trial. How would that help or hurt his case?
Well, defendants testifying aren't always the best idea from the standpoint of, you're nervous, you may not come across as eloquently as you would like or get all the points that you would like across. And of course, you're opening up to cross-examination where a prosecutor can completely dismantle you. But the fact of the matter is, this is a case that's about his mental state. And he has basically used the defense of insanity, saying he didn't understand right from wrong at the time that he killed this poor officer. So if he comes on the stand and seems kind of out there and really scattered, that could also play into the defense's argument towards insanity.
And Terry, aside from him taking the stand, the defense called a few witnesses. How do you think their case is progressing so far?
I don't think they're making very good legal arguments, and they aren't bringing on very good witnesses. The first witness was a private investigator. He couldn't even remember when he came to take the pictures at the Walmart. And in fact, on cross-examination, it was demonstrated that it took him 2.5 years to take those pictures. And the second witness wasn't that good either. She was trying to say that there were strike marks on the wall at Walmart. But I don't think the jury is going to care about that. All of Officer Clayton's bullets missed. And in fact, she was shot 4 times.
And they're trying to establish that she fired first. We'll wait and see. Melba, Terry, thank you so much. Everyone out there, thanks for joining us here on Law and Crime Daily. We're going to see you next time as we discuss justice in America.